Welcome to this episode of the Bellevue Brief, a new podcast series from the team at Bellevue Law. This episode is one of a special series of 10-minute podcasts providing insights into the Employment Rights Act 2025 and, importantly, practical actions for employers, business and HR leaders to take. I'm SusanneHartigan, Head of Legal Practice at Bellevue Law.
And I'm Anjali Malik, an associate at Bellevue Law, and today we'll cover the introduction to the Fair Work Agency, a new enforcement body under the Employment Rights Act 2025. So we'll be covering today what will change from the current enforcement landscape, key timelines of this new body, and what employers can do to get ready.
Thanks, Anjali. I think it's also worth flagging because the Employment Rights Act reforms are moving quite quickly in terms of consultations and regulations. So it's just worth flagging we're recording this at the end of January, just in case things change between now and when this podcast is published. So let's kick off with today's picture. So right now, most, but not all, but most individual employment rights are enforced through the tribunal system. There are some notable exceptions where the state can step in, and one example is national minimum wage enforcement is enforced via HMRC.
So, Suzanne, what is the change under the Employment Rights Act that's coming in?
So without getting too bogged down in the actual act, but we're looking at Part 5 of the Employment Rights Act 2025. And in this part, it sets out provisions that allow the enforcement of labour market legislation. Now, interestingly, in the Act itself, there is no mention of this Fair Work Agency. Where that appeared, and probably first appeared, I think, was in the government's policy paper, which is called Next Steps to Make Work Pay. And that was published back at the end, October 2024, when the bill, so the Employment Rights Bill as it was, which has become the Act, was first published. And in this policy paper, the government said that a new public authority would be set up called the Fair Work Agency. So what is the Fair Work Agency? So it's going to be a single state enforcement body, and it's going to bring together existing enforcement functions. So it will bring together that national minimum wage unit I've talked about that's under the umbrella of HMRC. It's going to bring together the Employment Agency Standard Inspectorate, the Gangmasters and Labour Abuse Authority, and it's also going to abolish the role of the Director of Labour Market Enforcement, which was originally set up to strengthen efforts to tackle non-compliance in the labour market. So what the Employment Rights Act provides for is the transfer of these functions to this newly set up body, the Fair Work Agency. And the Act also requires the Secretary of State to set up an advisory board, which is going to be based on a social partnership model, meaning there has to be equal representation from business, trade unions and independent experts who are going to provide advice to the Fair Work Agency. It was announced at the end of last year that this agency is going to be chaired by Matthew Taylor, who was a former chief advisor to Tony Blair and who led the 2017 Taylor Report looking at modern working practices under Theresa May's government.
Yes, so to summarise, the government's goal is to have a single place where individuals can go to for any help they're looking for and to use those resources more effectively. So the FWA will sit as an executive agency of the Department of Business and Trade, and this agency itself will be a distinct legal entity.
And I think it's also worth mentioning its limitations. So there was originally talk about the Fair Work Agency enforcing equality and discrimination protections, but the government did confirm last year as the bill went through Parliament that equality legislation isn't going to be within the Fair Work Agency's remit, well, at least for now. So equality claims will remain outside this body. Although, interestingly, in the fact sheet on the Fair Work Agency, and we had a number of fact sheets published for each of these reforms, they're quite useful documents to get a summary of the changes as well. It does say in relation to the Fair Work Agency that there will be flexibility to bring in additional legislation as new challenges emerge, so additional aspects of labour law or employment law into its remit. So it's sort of a watch this space as to its scope.
Yeah, absolutely. So let's talk about the enforcement powers.
Yeah. So the Act gives the Fair Work Agency wide-ranging powers to investigate and take action against employers who don't comply with the law. I think that's a fairly neat summary of it. Many are based on existing enforcement powers, but there will be new ones too. So Anjali, do you want to take us through some of those powers?
Yeah, of course. So the Fair Work Agency will be able to inspect workplaces and require employers to produce any documents or any evidence to show that they're complying with current employment law. So these powers mirror those already held by existing workplace enforcement bodies, so that they can already, enter business premises and review any records if they wish to. And these will be FWA enforcement officers who will be appointed by the Secretary of State. And these individuals will be legally empowered to enter any business premises that for any inspection they need to do without a warrant, if these aren't any kind of private dwellings. It will also be able to take cases to the employment tribunal on a worker's behalf, or for any legal support they might require. And where serious labour market criminal offences arise, they can also use enforcement orders backed by any criminal sanctions.
And in terms of bringing cases on behalf of workers, I think in all likelihood, that's probably going to be only those scenarios where a substantial number of employees have been affected. But again, we'll just have to wait and see.
Absolutely. And another thing they'll be able to do is where underpayments to workers are found, the agency will be able to issue notices requiring employers to pay workers whatever they're owed, essentially, and alongside a financial penalty that will need to be paid to the government. But also, importantly, employers found to be non-compliant may be required to cover the cost of enforcement action taken against them.
I think one thing we really need to flag up in this podcast, and a key change that this agency will bring, is the ability to enforce statutory sick pay and holiday pay. And at least on paper, this is a big change for employers to wrap their heads around. So let's start off with statutory sick pay. The agency is going to have responsibility for enforcing employers' liability to pay statutory sick pay, as well as being able to require employers to provide a statement about an individual's entitlement and other information about statutory sick pay. At the moment, how that works really is HMRC can decide if statutory sick pay entitlement is due if there is a dispute and the employee has to initially raise this. So it's slightly different or substantially different now what's happening under the Fair Work Agency. And then the second point I raise is about holiday pay, which is a big change. So responsibility for the enforcement of holiday pay and rolled up holiday pay is going to be within the remit of the Fair Work Agency. And there's an added separate obligation, but it's worth mentioning, that was put forward as the bill progressed through Parliament. And that is that employers are going to have to keep certain records relating to annual leave and pay for a minimum period of 6 years. So that is quite a change. And failure to comply with that will be a criminal offence, punishable by a fine. And in terms of that 6-year period for record keeping, that could potentially come into force in 2026. You mentioned, Anjali, about these penalties that the Fair Work Agency can potentially bring. And I think, again, another thing that's worth flagging is these penalties can potentially be very significant. So employers may face fines of up to 200% of the underpaid amount for each affected individual, although this will be capped overall at £20,000 per person. So if you think about it, if you're a business and you have multiple cases of incorrect holiday pay calculations, and holiday pay calculations can be fiendishly difficult to get correct sometimes, if you're then paying a penalty per individual person on top, that could quickly escalate into substantial financial liability for certain businesses.
Yes, Suzanne. So the potential financial exposure for employers is considerable. However, many employment law commentators have cautioned against becoming too concerned and bogged down in the agency until there is greater clarity on how the enforcement body will be funded.
Yeah, I think that's exactly right. There's been a lot of commentary around how effective is it really going to be? Is it going to get the necessary funding, etc.? There was media coverage at the end of October of last year, which highlighted how both the National Minimum Wage Unit and the Employment Agency Standard Inspectorate have experienced staff and budgeting cuts, which have affected currently their ability and their capacity to investigate and prosecute labour market violations. So it's definitely an area we need to wait and see what funding this agency gets and whether they're going to be effective in how they approach labour market enforcement.
And so, Susanne, I think a lot of people will be wondering, what is the timing on the FWA?
So yeah, it's imminent. So the agency is actually going to be established in April. What is less clear for us at the moment is when it will receive and practically exercise its enforcement powers. So we don't know that yet. So we have this establishment date. We don't know when operational readiness will be in place. So let's just move it away from sort of the detail of the agency and talk about practical steps for HR leaders and employers. So is there anything they can be doing now to get ready for its establishment? I mean, I know it's been established in April and we'll probably have a while till it's up and running, but anything employers can do now to get ready, Anjali?
So employers should already be compliant with their core obligations, such as national minimum wage and statutory sick pay. But the major change is that holiday pay will now fall under state enforcement. So this means that any errors are far more likely to come under scrutiny. If there are potential issues, it's prudent to review calculations and any processes now. So particularly for workers with variable pay, irregular hours, or any arrangements that involve rolled up holiday pay, as you previously mentioned.
Yeah, and I think as we've mentioned before, like holiday pay, especially for HR teams, can be such a complex and tricky area and can be an area where employers have perhaps left the analysis of whether they're getting it right, particularly as case law in this area evolves quite a bit. So it might be the time to get that cold towel around your head and look at how you're approaching your calculations to your holiday pay and those tricky areas like irregular hours, etc. Whilst we're here, I think it's almost worth just slipping in about the quick reform, well, not the quick reform, so slipping in about the reforms to statutory sick pay. This is sort of a separate area to the Fair Work Agency, but we may as well mention it here. So there are changes with the Employment Rights Act to statutory sick pay. And so from April the 6th this year, it's going to be payable from day one. So we're removing the 3-day waiting period, as well as the lower earnings limit is being removed. It's a shift, albeit a fairly straightforward one, for employers' payroll configuration and for sickness absence management. But these also need to be built into a business's readiness plan. So I just thought worth mentioning here as we're talking about statutory sick pay and holiday pay. So sorry, Anjali, let's go back to what you were talking about and the practical steps. So we've talked about checking inaccuracies and getting ready for these changes by looking at holiday pay calculations. What else can employers be doing?
Yeah, absolutely. So we really just can't stress enough that strong record keeping will be absolutely crucial in ideally keeping clear, accurate records for up to 6 years. With holiday pay moving into, state enforcement, as I was saying, any gaps or inconsistencies will be far more visible now. You should also start briefing HR and payroll teams on the upcoming enforcement environment, ensuring that they understand the new risks and update processes accordingly.
I think, as we've said, until we know a bit more about the resourcing of the Fair Work Agency, it's perhaps an area, yes, you can be doing stuff to get ready, but we don't need to necessarily get too concerned about this until we understand the resourcing and budgeting behind this agency. And we'll keep track of those developments as more details land, especially around the agency's scope, powers and resources. Thank you for listening today and keep an eye out for future podcasts to follow.